complainant's appearance, conduct, and representation. Article 50 of the Constitution guarantees the accused person the right of fair hearing to challenge evidence of the offense. The defense of presumption of majority age protects individuals who, without negligence, engage in relationships with someone who appears or claims to be over the age of 18 years, as it was in the case of Wambui versus Republic, a case of 2019, whereby Wambui was found guilty of committing an indecent act with a minor. The minor was alleged to be the age of 17 years. However, the prosecution's proof of age was not consistent. The birth certificate was unreliable, and the complainant's own claim that she was 18 years at the time of the alleged commission of the act. She openly lived with the appellant as his wife and openly conducted herself as an adult. The Court of Appeal found that the complainant's age was not proved beyond reasonable doubt, and that the appellant's belief in her majority age was reasonable given her conduct and the circumstances. In this case, Becky told Wambui that she was 18 years, she was a Form 4 candidate, appeared mature and voluntarily engaged in a relationship with the appellant. Wambui had no doubt to acclaim and therefore reasonably believed that she was of age. Despite this, the trial court completely ignored the defense of presumption of majority age and instead based on the age of the minor as a fact. The trial court denied the appellant a fair trial, violating the principle of justice under Article 50 of the Constitution. In conclusion, the trial court erred in law by failing to consider a mandatory statutory defense. The appeal should be allowed and the conviction and sentence quashed. Having guided the court on issue number 2, allow me to introduce my co-counsellor, Ms. Winslet, to guide on issue number 3.
May it please the Honorable Court, my name is indecent. I'll be taking through issue number 3. I beg to proceed. On to issue number 3, to answer the question as to whether the trial court, on the basis of the unsworn testimony, the court could conclude that the accused person committed an indecent act with a minor. My Lord, I beg to turn your eyes to the Sexual Offences Act Section 2(1), where an indecent act is defined as an unlawful intentional act which causes any contact between any part of the body of the person with the genital organs, the breast, or the buttocks of another person, but does not include an act of penetration. On to my first link, I must first say that Becky had presented herself to Wambui as an 18-year-old and thus not a minor. And in the Sexual Offences Act Section 8(1), it states that if it is proven that a child deceived the accused into believing that they were over age 18 at the time of the alleged commission of the offense, it is established that the accused reasonably believed that the child was over 18, and thus the offense of committing an indecent act with the minor cannot be proven. And so in our instant case, Becky had presented herself to Wambui as an 18-year-old, as it has been established in paragraph 4 of the fact sheet. And so I must say that Wambui indeed knew that Becky was 18-year-old, and thus she wasn't a minor because of her testimony to Wambui. And on to my second link, I must also state that the main ingredients of the offense of committing an indecent act with a minor are: it must be proven that the victim is a child by the law, and as you've stated, that Becky had presented herself as an 18-year-old to Wambui. And it must also be proved that the act was intentional, and also it must be proved that there was a contact between any part of the accused person with the genital organs, the breast, or the buttocks of the child of the victim. And there must also not be an act of penetration. In our instant case, I must say that I have reread the fact sheet severally, and there is no place where the complainant has said that either Wambui had touched either of her, had come into contact with either of her genital organs, her breast, or her buttocks. The complainant only talks of the appellant having sex with her, and it is proven that the complainant was not led to describe how the sexual act had unfolded and which part of her body was touched by which part of the body of the appellant. Because of this evidence, I do not see where it is evident that the offense of committing an indecent act with a minor was proven, since Becky, there is no place in the fact sheet where Becky had stated that Wabwire had touched either her genital organs or her breast or her buttocks. She only proved that there was penetration, and as it was established in the Sexual Offences Act Section 2(1), it was stated that in cases where for a person to be proven liable of an indecent act, there shouldn't be penetration, and from Becky's testimony, she proved that there was indeed penetration. Hence, the accused cannot be held liable of the act. And on to my third lift, I must say that the unsworn testimony, if I turn on to Article 52A of the Constitution, it guarantees the right to a fair trial, and hence the accused cannot be convicted on untestified or uncorroborated evidence. Therefore, the unsworn testimony cannot be used to amount to prove that the accused was indeed guilty. The Court of Appeal should indeed look into the facts and make its own concluding and its own reasons as to whether the accused was guilty by not relying on the past court's decisions. And from all this, I must say that indeed innocent Wabwire was not liable of the act, as there was no proof that he had committed an indecent act to the minor, since it was not proven that he either touched the minor's breasts or the genital organs or the buttocks of the minor. And also the minor herself had presented herself to Wabwire that she was 18 years old. And also not forgetting the fact that at the time, at 7 p.m., Wabwire had asked Becky to go back home, but Becky refused. And also, he again asked Becky to go back home at 9:30, and Becky stated, giving a mere complaint that the area where she was coming from, it wasn't insecure, and so she begged and persuaded the accused to go with her to his home. And so she had consented to the accused, and the alleged act of committing an indecent act to the minor cannot be proven. To this end, I will therefore leave the room to my co-counsel Mwatu Makoa to take us through issue number 4.
Court, my lord, my name is Mwatu Makoa, the last counsel appearing for the appellant side of the matter. I beg to proceed. Diving into the last issue, which invites this honorable court to respond to the question as to whether the 10-year sentence imposed by the trial court is unfair, harsh, and excessive in light of the mitigating factors read. My lord, I second the appellant who submits that the 10-year sentence imposed by the trial court is unfair, harsh, and excessive, and urges this honorable court to set it aside. This is substantiated into 3 limbs of argument. Firstly, the trial court erred in law by treating the minimum statutory sentence as a mandatory. This deprives the court its discretion to impose proportionate sentences. This relates to a case law of Dismas Swafula Kilwake versus the Republic in 2018, where the court stated that sentences should be proportionate, hence the sentence was reduced from 20 years to 15 years. Secondly, innocent Wabwire being a first-time offender, this sentence is harsh and excessive, and violates the principle of individualized justice. My lord, according to Article 48 of the Constitution of Kenya, it says that the state shall ensure access to justice for all persons, and if any fee is required, it should be reasonable and shall not impede access to justice. Thirdly, innocent Wabwire, being a first-time offender, is only 20 years old, has a meager income, and takes care for his younger sibling. These are classic mitigating factors which sentencing courts are enjoined to consider when assessing the prospects of rehabilitation. This is related to a case law of BW versus the Republic done in 2021, where the sentence was reduced from 10 years to 5 years. In conclusion, my lord, we pray that this honorable court should uphold the trial court's acquittal on the defilement charge. Secondly, we pray that this honorable court should quash the trial court's conviction of committing an indecent act with a child. Thirdly, we pray that this honorable court should set aside the 10-year sentence imposed by the trial court and substitute it with a non-custodial sentence or a lesser sentence that accommodates the appellant's compelling factors. My Lord, I rest my case.
Thank you. I don't have the last counsel for the appellants. I have a few questions for the appellants counsel. I'll start with the last counsel, so you'll get back on the stand. The appellant was sentenced under Section 11(1) of the Sexual Offences Act, which prescribes that, and I make no comment at the moment whether your client was guilty or otherwise on the actual charge of indecent act. But the magistrate convicted your client of committing an indecent act. The section provides that any person who commits an indecent act with a child is guilty of an offense of committing an indecent act with a child and is liable on conviction to imprisonment of a term not less than 10 years. There is a principle in law of presumption of constitutionality of statutes. Before this court is not at least whether or not Section 11(1) of the Sexual Offences Act is constitutional. But we presume its validity. If we presume the validity of that section, and your client was in fact sentenced to 10 years in jail, the understanding is that you actually got the bare minimum that the law allows a court to impose. Why would we fault the court for imposing the bare minimum? It had a choice of imposing a harsher sentence than that on the precise terms of the statute. Can you have clarification on that?
My Lord, as I said earlier, this honorable court should, when making the sentence, should also look at the appellant's compelling factors. Being that,
yes, let me assume that all these mitigating factors are good, they are correct. Let me assume I believe them. Then I'm also faced with the express words of the statute. Not less than 10 years. Is that ambiguous?
the trial court ruled, when making the sentence, it ruled that the 10-year sentence imposed by the trial court is mandatory, and which deprived the court of discretion to impose proportionate sentences.
Why would I want the court on that position in view of the express words of Section 11(1)? Why would I fault the trial court for taking that position, particularly when I read Section 11(1), which says the imprisonment is for a term of not less than 10 years? Meaning, what the court gave your client is the bare minimum. It must have been a very sympathetic court that the choice of going higher.
My Lord, that it is the bare minimum, but you have to look at the mitigating factors raised by the appellant, and also provided that the innocent or willing is also taking care of the younger sibling. You also have to bear in mind that you will also influence the life of the brother to innocent or willing.
Okay, fair enough. I'll leave the first counsel on the stand to respond to a few questions in a minute. Your logic is that the factual position that there was use of a condom and that spermatozoa was retrieved is a contradiction.
Yes.
Correct? A condom is a product of mankind. It can get damaged. Why is the contradiction if it got damaged?
I must say that there indeed isn't any fact or any evidence that the condom was damaged during the act, as neither the appellant or the respondent has stated the fact.
So how would I presume that the retrieval of the condom is the spermatozoa is a contradiction in the absence of that fact? It's one of the possibilities.
Yes, I must say that indeed is a mere possibility, but it can't be used so as to help the accused to be liable of the act of penetration, because it wasn't proven.
Finally, you have said the DNA probability of 55% is too small a percentage to link the appellant to this spermatozoa.
Yes, sir.
What is the scientifically bare minimum DNA standard that one must pass before such a conclusion of linkage can be reached?
About the scientific facts, scientific percentage that should be, about the scientific percentage of the bare minimum, I must say that indeed I'm not sure of the percentage, but that 55%, it means that either that 55%, it can't be held against the accused that it belongs to him because of the genetic fact, either the spermatozoa belonged either to any of his relatives, so it can't be held upon him that he was the person that the spermatozoa indeed belonged to.
Finally, let me get some clarification on corroboration. You know what corroboration is, some independent evidence linking the accused person to the act, the subject matter of the conviction. Isn't this medical evidence in itself corroborating evidence?
No, I must say that it indeed is not corroborating, because there is no link as to how the spermatozoa, the alleged act happened a day before the medical examination was conducted, and when the clinical officer conducted the medical examination, it was found that the hymen had already started to heal. So there is indeed no link of the sexual act and the accused.
Just my final clarification from you. Is there a scientifically minimum time required before the hymen starts to heal? They're not fully healed.
Scientifically, the hymen, if the act was done a day before the examination was conducted, the hymen cannot start to heal. It takes a few days so that it may start to heal. So I think in the instant suit, I must say that in the instant suit, the hymen appearing to heal a day after the act was committed is indeed questionable as to how it could have started to heal on a day after the act had been committed. So it isn't clear. There is no clear link of the act that the accused was charged with and the medical evidences that was provided the next day.
Okay, I'll permit it because I'll have the final answer because of clarification on this one. Want us to make a presumption of adulthood on the part of this minor. What was the actual age of this child?
She was 17 years.
She was 17 years old. She had apparently been known to the appellant's brother for a long time.
They were schoolmates, not classmates.
They were classmates. Should the fact that they were classmates with the appellant's brother have led to a possibility of the appellant construing a more accurate age based on his own brother's age, because you can make a fair assumption of people advancing simultaneously in terms of educational progress and age. The minor and the appellant was known to the minor's brother.
Yes, she was young.
Sorry?
Yeah, she was young.
You are classmates
They were classmates.
with the appellant at Chebakali High School.
Yes, appellants plan.
Yes. Will that have aided the appellant in ascertaining the possible age of the minor relative to the brother he was schooling with?
What? It's not. The appellant could not have known that she was that the complainant was over the age of 18 because the complainant assured the appellant that she was 18 years old.
Okay. Fair enough. I think I would rest at that. For the appellant, we now move on to the case of the respondent.
Please, this honorable court, my name is Judicial, the lead counsel appearing for the respondent, the Republic. Alongside me is my co-counsel, Faith Cherop, Eugene Kichuma, and Lucy Kerevi. Granted this 30 minutes, my lord, I'll take 7 minutes to dispense on issue number 1. Faith, Eugene, and Lucy will take 6, 6, and 9 minutes respectively, and 2 minutes reserved for rebuttals. If that suffices, proceed to proceed. Much obliged. Turning to issue 1 on whether the trial court erred in finding that there was no proof of penetration to the minor by the accused, my lord, defilement under section 8(1) of the Sexual Offence Act has been defined as an act which causes penetration with a minor. It has 3 key elements, and that's age, penetration, and positive identification of the perpetrator. This is also emphasized in the case of Kaindu Kasomo vs. Republic of 2014, where the court held that the 3 factors must be satisfied for one to be convicted of defilement. The first key element, my lord, is age, where in the fact pattern, paragraph 15, the prosecution provided an age assessment report showing that Becky was 17 years, 1 month old, a child under section 2 of Children's Act, and any sexual contact with her amount to defilement regardless of the consent. To the second key element, which is penetration, penetration has been defined under section 2(1) of Sexual Offence Act as partial or complete insertion of genital organs into another person's genital organs. It does not need to be complete. Therefore, partial penetration can still establish the offence of defilement. This is supported in the case of Ali Kasim vs. Republic of 2006, where the court held that any degree of penetration, however slight, is sufficient to prove penetration and establish the offence of defilement. My lord, Becky's evidence in paragraph 9, where she testified that they had sex with the accused using condom, is legally sufficient under section 124 of Evidence Act, which says that the complainant's testimony alone is sufficient to convict the accused if the court finds it to be truthful. Also, Becky's evidence was corroborated by medical findings, where we find that the medical officer in paragraph 12 testified that the complainant's hymen was broken and there is presence of degenerating spermatozoa. Also, the medical report shows that there is DNA compatibility of 55%. While the defense says that the 55% is inconclusive, the law says that the medical finding is just a corroborative evidence and not a sole determinant of guilt. So the DNA results is just a corroborative evidence. It corroborates Becky's testimony, as in the case of Republic vs. Joseph Kimani Zhao of 2014, where the court held that any DNA results is just a corroborative evidence and not a sole determinant of guilt. My lord, also the defense rely more on condom theory. However, logically, condoms break. And when condoms break, that's when the semen is deposited to the vaginal swab of the complainant. So, that the use of condom does not indicate penetration. To
to the third key element, which is positive identification of the perpetrator, my lord, this means that the complainants and the witnesses must be able to recognize and identify the accused as the one who committed the offense. In the present case, the complainant in paragraph 9 testified that Wabwire has been her boyfriend ever since her last birthday. Also, the circumstantial evidence where the complainant's mother, Miss Otieno, testified that she found Becky lying shirtless on Wabwire's bed that 17 morning. And also, Wabwire's neighbor testified that she saw Wabwire entering into the house that night, that 16th night, before he was arraigned in the magistrate's court. This shows that they were able to identify and recognize the accused as the one who committed the offense. So within the fact pattern, we are not told that there is somebody else who was with Becky. My lord, having satisfied the three factors which is required under the law, the respondent humbly submits that the prosecution fully proved the three elements beyond reasonable doubt and urges this court to dismiss the appeal and uphold the conviction. That being the nature of my submission, unless the court has any questions.
We'll come back to the questions together.
I cede the floor to the next answer. Thank you.
May it please this court, I'm Cherofei, appearing as the second counsel for the respondent. I intend to take 6 minutes to discuss on issue 2 on whether the trial court erred in failing to consider the presumption of majority. If that suffices, I seek to proceed. Much obliged. My lord, it is our humble submission that the trial court did not err in rejecting the defense of presumption of majority. My first limb of submission is on defilement as a strict liability offense. Under Section 81 of the Sexual Offences Act, a person who commits an act which causes penetration with a child is guilty of an offense termed defilement. Therefore, the strict liabilitiness on defilement does not depend on the belief, but rather the actual age of the victim, who is Becky and is 17 years old, 1 month. In Matintaro vs. Republic 2016, the Court of Appeal held that defilement is a strict liability offense and consent or mistaken belief in age cannot be defense when the age of the complainant is proved to be below 18 years. My next link of submission is on a reasonable man test. Wabwire is 20 years old, mature enough to have inquired Becky's identification card or school details. A reasonable person could presume a school-going girl as a minor, but failing to do so showed Wabwire's recklessness and disregard. In Evans Wanjala Wanyoni vs. Republic 2019, the High Court held that the defense of reasonable belief is not available to an accused who made no inquiry as to the complainant's age. My next link of submission is on proof of age is conclusive. In fact, paragraph 15, the age assessment report was submitted and it shows that Becky was 17 years old and 1 month during the alleged incident occurred. The evidence was unchallenged by the defense. My next link of submission is on a protective purpose of the Sexual Offences Act. The Act was enacted to protect the minors from exploitation regardless of maturity. Allowing reasonable belief, defense easily would open loopholes for offenders to claim ignorance. Your Honor, in the light evidence and law, claim of reasonable belief in Becky's age is without merit. The age was conclusive, Wabwire made no effort to verify the Becky's age, and the statutory protection afforded for minors must not be diluted by subjective assumption. Therefore, we submit that the trial court did not err in rejecting the defense, and the conviction and sentence was proper, consistent, and lawful with both the letter and the spirit of the Sexual Offences Act. Unless there is clarification from the bench, I conclude my submission on issue 2 and yield the floor to my co-counsel.
Please, this honorable court, my name is Eugene Kachumba. I appear I appear for the prosecution to dispense on issue number 3, whether on the basis of unsworn testimony, the trial court could conclude that the accused person committed an indecent act with a minor. My lords, the prosecution submits that the magistrate was correct in finding guilt. The mere statement by Wabwire that he touched the complainant breast falls under the definition of an indecent act under section 2, subsection 1 of the Sexual Offences Act. Your Lordship, use of unsworn testimony does not validate convictions, as courts are entitled to rely on accused admissions where it was voluntarily and supported by other evidence. As the admission was clear, deliberate, and corroborated. The complainant testimony, which she said that she had sex with Wabwire, it was corroborated with the surrounding evidence, which was the forensic evidence, the neighbor's admission, which she said that she saw Becky enter into Wabwire's house at night, and where she was found in bed with Wabwire. These findings left no reasonable doubt that the act took place. Those are our humble submissions on issue number 8. I cede the floor to my fourth counsel.
May it please this honorable court, appearing before you is Lucy Kerebi, counsel number 4 on the respondents, addressing issue number 4 and prayers in the next 10 minutes. That being the course of my submission, I beg to proceed. Much obliged. I'll be answering the question on whether the 10-year sentence imposed by the trial court was fair, harsh, or excessive in nature of the mitigating factors raised by the accused. My lord, we humbly submit that the 10-year sentence imposed by the trial court to Wabwire was fair, neither was it harsh, and it was not excessive in the nature of the mitigating factors raised. I'll be submitting my issue into 2 limbs. The first limb is for the 10 years to be declared constitutional, and the second limb is for the court to maintain the 10-year sentence imposed. Back to my first limb, my lord. My lord, I'm well guided under section 11(1) of the Sexual Offences Act, which provides a mandatory minimum of 10 years imprisonment. Hence, the court should rule under the guidelines of the Act. In reference to the case of Judicial versus the Republic, the Supreme Court declared the original minimum sentence constitution and that the accused must complete the sentence imprisonment imposed. My lord, to the offense committed by Wabwire, the sentence is very fair and it should serve as a punishment and work as a warning to the public interest, as it also protects the rights of the minors. My lord, in the case of Wanjema versus the Republic, the court held that the Court of Appeal can only interfere a sentence if it is illegal or under wrong principles. In the facts under paragraph 16, Wabwire raises issues that he is a first-time offender, a young man of 20 years, and he is also a total orphan with a younger sibling whom he takes care of, despite the less income he gets from his furniture shop. My lord, the court acted fairly in consideration of the mitigating factors, and it gave the minimum sentence and nothing more than that. Allow me answer the submissions of the fourth counsel on the Appellants, saying that the court should consider the mitigating factors. My lord, does it mean that Wabwire being an orphan, the court cannot, it limits the court from convicting him? Wabwire being a first-time offender, does it mean that he can break the rules and the court not to convict him? No. In consideration of the mitigating factors, doesn't mean that the court can't convict wrongdoers, and doesn't limit the court from convicting him. The sentence was within the statutory limits and therefore lawful. Your Honor, the respondent do submit that the sentence is not excessive and is constitutional as it was imposed within the law. I'll be heading to my second limb for the court to maintain the 10 years minimum sentence. Since the sentence was within the right principles and on proper judicial discretion, the appellant should maintain it.
In Onjema's case versus the Republic, the appellate court should not interfere a sentence unless it is illegal, which is not in Wabure's case. The sentence promotes justice as it protects the public interest. My lord, in the case of Joshua Gishuki versus the Republic, the appeal was dismissed by the High Court, and the High Court affirmed that where defilement is proved, statutory minimum sentence must apply and the court cannot substitute it with a lesser term. This should also apply in Wabure's case, as the defilement was proved and the court should convict Wabure to the minimum sentence under Section 11(1) of the Sexual Offences Act. Also, in the case of Mura versus the Republic, the court held the original sentence fair and proportionate to the offence committed. My lord, in the doctrine of separation of powers, it is the Parliament that makes laws under Article 94(1) of the Constitution. And the court has no power to override that law. Hence, the court should exercise its powers by convicting Wabure to the minimum mandatory sentence under Section 11(1) of the Act. In conclusion, my lord, the respondent submits that the trial court exercised proper judicial discretion and the 10-year sentence imposed by the trial court was constitutional as it was imposed within the law. My lord, in light of our submission, the respondents praised that 1. For the court to declare that the trial court erred in finding that there was no penetration on the minor by the accused. Second prayer, my lord, is for the court to declare that the trial court did not err in failing to consider the defense of presumption of majority age. Third prayer is that the court declares the trial court can indeed conclude that the accused committed an indecent act with a minor on the basis of unsworn testimonies. Fourth prayer, my lord, is for the court to find that the 10-year sentence imposed was constitutional as it was imposed within the law. Fifth prayer is that the court finds that the minimum sentence imposed by the trial court is fair and proportionate to the offence committed by Wabure. There have been no more clarifications. My lord, the respondents we rest our case. I beg to cede the floor back to the bench.
Thank you, Mr. Counsel. I have a clarifications. I'll start with you, Minister Remaining. I'm trying to understand what the outcome you want from this course. First, you want us to overturn the findings of the trial court on the charge of defilement, correct? Secondly, you want us to uphold the findings of the trial court on the offense of indecent act. Am I getting it right? The question I have is can we have it both ways? Can we have a conviction both on the offense of defilement and on the offense of indecent act, considering that the charges were presented in the alternative? Let me see how to get around that. Yeah.
Much obliged, Your Honor. My lord, my submission is that the court dismisses the appeal.
But you raised the issue of the finding of the court on the issue of penetration. You flagged as an issue, because on the issue of penetration, it is the appellant who benefited from that finding. Yes, that is how he was acquitted of defilement. You want us to set aside that finding on penetration and find that in fact there was penetration.
Yeah, there was
To what end? The end of then making a guilty finding on defilement.
My lord, defilement was proved. And the statutory minimum sentence must apply in the case of Wabure. And on the issue that the fourth counsel of the appellant said that the sentence must be quashed, sure is the court that he went ahead and asked.
Nothing to from a listing counsel. He went ahead and he has received the answer. The answer that asking means what? Asking what is your age?
Me too.
No, I'm talking about that child. Asking him what is your age?
Me too.
Now, if this appellant had asked this child that question, we already know the answer she would have given because she gave it. So you're saying he was wrong to rely on her answer, but he would have been right to rely on that answer if the answer was prompted by his question. You're saying he was wrong to rely on her unsolicited answer, but he would have been safe if the same answer came solicited.
Yes.
Okay.
If he went ahead and asked another person about the age, and that person tells him that she's indeed 18, that will be an abuse plus defense. But in the present case, the appellant never inquired from anyone else.
What do you want us to do with this issue? When you want us to overturn the finding by the trial court that there was no penetration.
Yeah, the trial court had in finding that there was no penetration.
So if we agree with you, and if I'm supposed to agree with you, then what?
We dismiss the appeal and uphold the conviction.
But you see, the issue that there was no penetration only served one purpose. The purpose being the accused was acquitted of the offense of defilement.
The accused may not should be charged or
To be convicted. He was already charged. So you want us to convict him of defilement.
Yes.
Which then begs the question I asked your colleague, Lucy. If we agree with you on this issue and convict the appellant on defilement, what do we do with the conviction on indecent act? Considering that the two are charged in the alternative.
Well, all the judgment should be upheld as there was proof of indecent act and proof of defilement.
Notwithstanding that the prosecutor who owns this case opted to charge them in the alternative, one. Number two, would he possibly have charged both of them as separate counts without charging them that? No.
No, well, you will not be charged on separate counts.
Which then begs the final question that I had with your colleague. Again, if we agree with you on the first issue, that will stand in my mind. What do we do with this sentence? The appellant is serving a 10-year day term on the conviction on the alternative count. But you actually want us to convict on the first count, defilement.
I don't know. The accused should be convicted on both accounts, not on separate basis.
I'm not sure that's something I can do with law, but even if I assume something I can do, even if I assume so, what do we do about this sentence if we agree with you?
The sentence should be upheld, my lord.
You retain the same 10-year data.
Yes.
Okay. I think that's it because the questions to the other two counsel are in the same area, so I will not call on them in the interest of time. And is there right of rebuttal? Right of reply? The appellant? Do you wish to reply? You are entitled to reply to their submissions. You may take that chance or you may not have anything to reply, in which case then you may leave it at that. The choice is yours. Take a seat, counsel. Take a seat. The appellant, please, counsel.
In the prayers of the respondents, they asked the court to find that both the act of defilement and indecent act should be found to be upheld. So I must say that their prayer cannot be upheld, because if indeed there was penetration, which I must say wasn't proven, if indeed there was penetration, to say that the accused indeed committed the act of defilement, the accused can't also be charged with the act of committing an indecent act with a minor, since in the offenses of committing indecent act with a minor, the act of penetration should not be there. So I must say that their prayer of convicting the accused of both the offense of defilement and committing an indecent act to the minor cannot be upheld.
Okay, before you go, counsel, I just had one clarification to see. The issue of touching the child's breasts came from the appellant's unsworn statement. Is it your case that the court ought to have ignored that fact coming from the appellant himself, or what exactly was the court supposed to do with that fact?
Okay, in accordance to that fact, I must say that first the accused had given an unsworn testimony, so it can't be used against him. And there is a possibility that because when Becky's mom stormed in the room, she found that Becky was shirtless. There is a possibility that Wabwire merely touched the accused's breast, and it may have came into contact with his body. So it can't be used to prove the fact that indeed Wabwire touched Becky's breast.
I'm struggling with this. If he says himself he touched, it's an admitted fact. He says by himself. Law, there are matters that dispense with proof, that take away the burden of proof. One of those matters is admitted facts. Admitted facts. Example.
Yes.
Let me ask you the question. When an accused person takes plea, an accused person does not take plea on oath. He makes these statements not on oath. The plea itself. But if he says guilty, the court does not tell the prosecutor now proceed and prove, because the question of guilt is admitted. By parity of reasoning, if an accused person does not keep quiet when he's put on his defense, does not keep quiet, he opts to speak, although not on oath. Obviously, he can't be cross-examined, what the law says. But if, while speaking not on oath, he says, I touched her breasts, can the court wish away that admission?
No, I don't think so. From the facts that I say, maybe by saying that he touched the breast of the complainant, I must say that maybe, yes, he did say that he touched the complainant's breast, but the court should also consider the fact that maybe he would have done so by the breast coming into contact with his body, but he didn't consider it.
Thank you. And that marks the end of our hearing. We will not adjourn the court. We will give the court just some 5 minutes to consider the facts, then call the court back to order for purposes of delivering the verdict. So everybody remain seated. back in session. I'll make a few overall comments on my observations. And because I must pronounce the results, I'll pronounce the results. First, I am thoroughly impressed by the standard of commitment by the Appellants Law School at the Tom University in the Republic of Kenya. I say this for a number of reasons. One, when invited here, I was told that the learners I'm going to deal with are first-year students. I know you are dean for many years, and is not a deceptive person, so I believe that fact to be true. But the standard I have received here is a very high standard in comparison to the level of learning I was told I was going to interact with. To that extent, I am thoroughly impressed by what I call the take-off point of this law school and its learners. I must say this because I may not get another chance to tell you these things. That assuming what your dean told me is true once again, that you are the pioneer class, you only fall in the category of the following category that I know. One, Professor Justice J.P. Ojuang and Senior Counsel Mr. James Agri Orengo. Because those two in 1970 were part and I've seen a lot of them here. Mr. Kechowiti. I hope my eyes are not serving me wrongly. I have a short sight, so I see people and I presume I've seen the correct ones. In that category, I hope I'm not misrepresenting you, that was the pioneer class of the Faculty of Law at the University of Nairobi those years. Those people usually carry an extra burden to themselves because we have no other knowledge of Tom Mboya University School of Law. Our very first knowledge of this school is through you. You are the lens through which you see that school. And therefore, if we see promise when we look at you, we conclude this is a promising school. If we see disaster while looking at you, we conclude this is a disastrous school. I'm happy to report I have seen promise. As I go out there, I will tell the whole world that at the Appellants Law School at Tom Mboya University, there is promise. But let's remember, promise is just that, a hardy. A promise is dependent on now delivery. We shall once again look at you at the delivery stage. But the inception is very good that we have a promise. The burden you carry, one of the things as I was debating my engagement here today with colleagues was, what kind of courage does a parent have to take their son or daughter to a law school without a history? It's extreme faith. It's extreme faith. In our day-to-day lives, we consume tried and tested services, tried and tested commodities. The dominant reason why all of you in this room have a Safaricom line is because it is tried and tested. After all, there are many other service providers in this country, which none of you has dared buy their line. This one is tried and tested. And that when you bring your child or daughter to the Appellants Law School, is an act of extreme faith, particularly when there are 20 other licensed and accredited law schools by the latest statistics from the Council of Legal Education. The question for me is whether you are worth that faith. Once again, I am happy to report that preliminary results show that you are worth every aspect of that faith. Your capacity to comprehend facts is interesting, is impressive. Your capacity to comprehend basic principles of law, and I use the word basic principles of law because I understand your level of learning. And even as I posed my questions, I was able to know how far to go because I'm also conscious of the fact that some of these questions will require greater advancement in learning itself before they become clearer to you, including clinical internships, clinical attachments, judicial attachments, for you to be able to have these principles make practical sense to you. Your organizational structure, the way you framed your issues and allocated them and stuck to your issues, is something I have found extremely impressive. And at your level, the manner of dressing was also satisfactory. So I have had difficulties in making decisions, but the teachers of old told us that as a judge you must eventually decide. It's not a choice you have, you must decide, even if you are wrong. The law can withstand a judge who decides wrongly. The law cannot withstand an indecisive judge. And therefore, in the final analysis, on the knowledge of the rules and principles of law governing this dispute, you scored equally. The appellant scored 15 out of 20, the respondent scored 15 out of 20. You tied. You all refer to the same law. We had different interpretations, but you all knew which laws, which case laws touch on this subject, with varying degrees of how you applied it, but you knew it. Number two, on the knowledge of the facts from the fact patterns given, the appellant scored 15, the respondent had a slight edge, he scored 18. On structuring your arguments and allocating them and ensuring that each counsel stuck the structure, you scored as the appellant 18, as the respondent you scored 18, and you tied. On the persuasiveness in response to my questions, the appellant scored 15 out of 20, the respondent had a slight edge, scoring 18 out of 20, and on the dress code, you tied. You scored 15 each. I'll say something about it around the final verdict. Does the higher education laws was still give learners a stipend for judicial attachment? If it does, I trust that many of them will get their first quotes from the stipend. That's how many of us survived the teaching industry, and therefore I'm very understanding of where we are. So you tied at 15 each. In the final analysis, the appellant got 78 out of 100, and the respondent got 84 out of 100, and therefore the respondent has it. May the court rise. Thank you so much. You may leave as guided by the dean. Thank you.
We will ask that you ask me to leave, then I can organize. I believe you put them I don't even go anywhere else for the round 4. So please, we all meet on the round 4. All the students. Oh yes, yes. They are asking for a photo with the bench, the bench that where do you have the photo?
Yeah, the pictures are there. Before change. I think I thought maybe one pages will come early when you manage because you'll spot live bado tuko live tukiteremka auditorium. Okay, that would be a nice thing.
Yes. Na wengine nataka niwapeleke kwa VC.
So we can go with them when you turn around for VC.
Yes, you may have that. Asante sana.
Yaani
Tupige picha hapa au huko nje?
Eni hata huko chini.
I didn't see him clearly.
Yeah, he's coming, he's coming. Tusimame wapi?
Yeah.
Hapa. Haya, tunasimama hapa. Do you want the judge to sit or tusimame tu wote?
Tunasimama tu wote.
Okay.
Mama, the cameraman, where are we standing?
Zunguka hivi tuwe na hapo.
Okay. Guest of honor, please. Let the guest of honor come in.
The guest of honor comes to God. We can balance this.
It's okay now. Okay.
Yeah.
That's the only time when being short becomes an advantage. Because there's consensus, you come in front.
We can't see you now.
Anaonekana?
Anaonekana.
Ah.
Okay.
Say cheese.
Cheese.
Yes.
Cheese.
Yes.
One small cheese.
Yes.
Thank you.
Thank you so much.
Hi, how are you? Well done. You guys are phenomenal. This is only Dean can tell us. I mean,
They look like for Diaz.
They're even better than for the years.
They look okay.
I'm a lost person. Yes.
Are you
Nitumie hiyo kitu yenye nataka tuweke. Namna gani? Kwani ona au visa ishafika? Au wenye wanaenda huku juu kwa visa ishafika? Unaona sasa hii inafeka. Baba, hii inafaa ichajiwe. Unaona hii.
So what did you tell them now? Run something about Tomboya.
Run something about sound. I know, yeah. I know. But the first one. I do. Fine. Maybe. Mike legalisimo. Solo.
but of course also to equip our students with the knowledge and skills that they need. Thank you very much for listening to our program. That's all we have. Thank you.
Most of the time, you're looking at me academic and I suggest that you are very serious, yeah? Yes, we are launching an also. Yeah, so now that you're academics, let's laugh academic activism, yeah? Yes. That one is for serious, not jokers like us. Anyway, yeah, thank you so much, Dr. Indeed, the vision is laid, it is plain, and without a doubt, we are sure that the only work that remains is achieving the same vision. It is now time that we get to speeches, and I'll be welcoming the Dean, who will be inviting each and every of the parties that will be giving us speeches. Bwana Omara, karibu.
Thank you very much. I'm realizing I get called because he was last my student. Good morning. Good morning. Good morning, everyone. Good afternoon. Good afternoon this morning. Thank you very much. I want to promise to be out here with everyone, but for 30 I'm handing this back to everyone. And I'll just ask Rogers to come and Fiona come. You should know who you should know. You know people who make up the founding faculty of where CMG College, faculty of law from the university. I have the privilege also working with my former students, so I'm doing well. Say hello.
Good afternoon, everybody. Good afternoon. My name is Fiona Oguru. I form part of the founding faculty of law in
Rogers, we are speaking.
Good morning once again.
Good morning.
Thank you very much. We are excited to have you here. Thank you.
We are very much. We are fun to learn, and we are out there thinking about what it takes to join this faculty. Please reach out, and we want to know this what it should be. Now, I will not do speeches, but I want to also ask that we do speeches. I will ask yourself, you've been admitted to serve as an advocate higher education, 15 years and above. Let me just say you've done 15 years and above. 15 years and above. Okay, 15 years and above. Okay. If you have done 15 years and above and you're not a chief guest or a deputy chief guest, then I will ask that you come in front because you form the parliament. I'm going to ask very easy questions. Let's come. You are panel.
Now you can't less than 15.
You don't mind coming from. You don't mind coming from. Please come. Yes. Come. As they come, I'll do it also because I'm inviting LSM former Madam Peter, please come and speak to us. You guys welcome English gentlemen and women. But I'm mean, but you can't more than you don't mind this guy. Okay. Anyone else? I thought but Amanda, I know you will come, but you have to speak. You will not. Please, let us say, let's appreciate
all also good afternoon. Before I say very few words, I would like to sing the chorus of a song that you can sing here, and I really feel good. I don't know if our students have learned. Have you learned the school anthem, the Tomboy University anthem? No?
Tell them we are the people from
Lawyers don't answer like this. Just look at me because you say I have not learned. We are the nine portions, Tomboy University. Our pillar is innovative enterprise research. Our strength is knowledge for sustainable. Innovative enterprise research. Our strength is knowledge for sustainable development. Tomboy a center of excellence, the hub of development, the fountain of knowledge and skills, the place of innovation. Tomboy, financial or talents, the home of creativity. Resilience is our culture to the peak. We are an enterprise. Yes. I undertake to come and teach the law faculty. So that next time we have an official function, we can do the national anthem, the East African anthem, and the Tomboy University anthem. Mimi ni mwanasangara. Well, you want to do it in Swahili? Yes, that's because Mimi is Mwanasangara. In fact, I really hope one of these 5 days I get to join your faculty, get a bit of the singing energy. See video? Yes. So my name is Peter Adoyo, advocate. Peter Adoyo, I'm an advocate of the High Court of Kenya in private practice. I practice as Peter Adoyo Company Advocates here in town. I have also had the privilege of serving Homa Bay County as the LSK chairperson. I handed over to my sister Nancy Yarige just about a year ago. She has sent me with her blessings and her greetings. I am very excited that we have this forum today where we officially launched the LLB program. And I want to, actually as I was working in, there's a student who was leading me and she was telling me, you know us, we are the pioneers, we do not even have people to refer to. If you have anything you don't know who to ask. I want to tell you that we are in Homa Bay, we are over 30 advocates. I am one very talkative one, I'm very approachable, my law firm is just there. Feel free to interact with us when you have time, because we stay around town. We are there as your big brothers and sisters to guide where there is need. And I believe your teachers are also very capable, and together, Wanasangara will be able to arise as the best LLB institution in the region. I'm encouraging you. I have met some of the people who were in school and they remember me as maybe you see the people go to campus and they think it's people relax. Actually, the MC was asking me, this list, yeah, because I read, I believe in reading and it's paid off. So I'm just encouraging the young people who are just starting to pursue their LLB program to have a independent diploma. It is not for the lazy. Just study, read, develop a lot of interest. Meskia Tomboya, innovation. You have to just go out from doing, love what you're doing, and it shall be well. Meskia, It shall be well. Love what you're doing, have a lot of enthusiasm and interest, study even beyond what you are taught, because we are not learned people, because we are supposed to know a lot. We are supposed to know almost everything. So we shall not call you a learned fellow if your knowledge is very little. That means you have love reading, love your studies, read beyond what you are taught. Because out here we deal with all manner of things, even things that you lecturers didn't tell us. A person comes to your office and they tell you things that are new, you never heard of anything. And you know what? You are supposed to offer a solution. You cannot tell them all. So you have to be well read. I wish you all the best. I would like to invite my fellow advocates who are here from Homa Bay chapter to rise, wave, maybe just introduce ourselves, and we can get hand over the program. I'll just introduce Senior, although I know she'll be the target. I'm giving her a chance to introduce herself because it was still our airtime. Maybe say something in maximum minutes.
Good afternoon, ladies and gentlemen. God is good all the time. One and foremost thing that I believe in is God first. Praise the Lord. Behind everything, behind all the achievements, my dear students and learned friends, it is God. Praise the Lord. We need God even as you are here studying, so that you can be looking up to God in everything. Is that so? There are some students who are aware of frustrations in studies. They were looking at relatives for help. They have not been helped. So what you need most is God. As you have been told, my name is a member advocate. I am the second senior most advocate in this city of Homa Bay. I'm privileged to be so. I'm 32 years old in practice, having graduated or having been admitted on 15 July 1993 in the role of the advocate. God has preserved my life, as you can see. I'm gracefully aging, as you can see, and all this I attribute to the Almighty God. What I'd like to emphasize to the new learned friends, I know you are going to make it. If you believe, you will make it. Praise the Lord. I'm told in my village that I started saying that I'll be a judge at the day when I was in 73. And I used to tell the ladies that we used to go to fetch water, bring firewood, that one day I will be a judge. And that came to be so. That God privileged me to have been a magistrate first. I was an advocate first, I went to the judiciary, and later I came back to be an advocate. All this has been by the grace of God. But what I've learned that I would like to share with you is that in this profession, all that you need is hard work. You need determination. You need that culture of living that my learned friend Quinta told you about. And above all, you need discipline. My father used to say that without discipline, you cannot reach your goal. Is that true? Yes. Many people are fed on the way, like those seeds that were thrown, that were being scattered in the Bible of Jesus Christ. So the way is wrong, but please focus on discipline. And as you remain disciplined, God will help you to reach your goal. That is all that God wants.
Thank you very much, Nia.
Good afternoon. My name is Yusuf Ali. I'm an advocate of the High Courts. I work with the Quinta Yes, I will just quite a little about what is happening today. This is a good initiative, and I'll just as a let's say, there's a thing that your past years and what happened in the movie was right pictures. And we just want to encourage you. The future is bright. See us standing here. There is a lot going on, and we are encouraged to continue doing the same. As I'm going to just encourage that, as she said, you are always welcome to offices. Start early, work hard, as I say, and just make sure that each and every statement that you see here, these are your seniors. They've walked along that path and they know a lot. Just make sure you follow the instructions and don't do well. That is all I need to do.
Thank you so much, Mr. Nani. With those main remarks, we want to say thank you so much for having us as part of this program. We shall partner with you as much as we can.
Hi, we're done with let us appreciate and now that Dr. Mima said the speech, she's saying her piece. Let us have, unfortunately, the court, the judiciary and the foundation here, all of them, they have been summoned to the Zoom training. So they are training with Zoom to make it. Now, I want to ask, you take the opportunity now. I don't see any other person, your student are come here. And I want to give questions, two or three questions. Number one, you are practicing. Jack Oronga is an advocate practicing in Nairobi, and he's done good. The Professor Wire has very serious good stories about it. But I will ask two questions. One, when were you at law school? When did you go to law school? When were you at maybe you ask because I am in charge of this. Introduce yourself briefly, sir.
Good morning. My name is Jack Oronga. I am an advocate, a practitioner. I almost forgot. Actually, I began my 15th year of practice 2 days ago.
That's why you fear to come.
No, I actually forgot it.
Which university?
I actually went to university in Uganda. I went to Kampala International University in 2005.
What do you remember? It was too hard for you. We hope that we can get these best experiences and then replicate here. What do you think stood out?
What stood out actually, we were fairly new university as well. I think I was in the maybe third year. We were the third cohort of law school. So when I came here, it was actually an interesting experience to actually find the first cohort of Toronto High University School. What stood out is the memories. I had my senior employer, and I'm grateful I hear you have very interesting stories about me. I hope they are positive. I had him say that one thing will never change, that you are the first cohort. You will always be a reference point of this university. People will come and I had to point to the class of was it 1971? 1970, the University of Nairobi School. That memory will never be erased. Similar, you now tread, how many years? I think it is now 55 years later. You now tread the same. It is a memory that you carry you and follow you. So how we choose to make it will define how we will be in the future. Usually, so to use this example, I am sure back in the village, you find those people who do nothing in the village, but they know people. Somebody passes, somebody is in the TV and they tell you that was my classmate. And you wonder what happened. Don't do that person.
Thank you very much. But last question of you. What kind of young lawyer would you want to be? Can't your local mother. What do you, the employers or lawyers, look for in a young advocate or a young lawyer who wants an internship or a placement?
As my colleague Kunta said, unfortunately, you know there's no of that. One is hard work, two is resilience, three is discipline. It is a long road. There are no shortcuts. The attributes, I should say, law is it's a learning path. Even us, trust me, we say now, we get something new every day. So I would want somebody who is willing to learn, to somebody who is disciplined, somebody who takes the job or who is hard work.
Thank you very much, Jack. I appreciate Jack. And I remember my teacher. The teacher of anyone, if anyone says they studied law and they are here, and they went to the University of Nairobi, the university, and then they must have met my teacher and now my friend. Prof, how are you? Welcome to Congo. And introduce yourself to those who don't know you.
Okay. My name is Okech Songiti. I was admitted to the role of advocate in 1977. If they pass through the University of Nairobi, they pass through our hands. I was also the dean of the School of Law, Appellants campus, University of Nairobi, for 4 years, and then I became associate dean at Kisumu for 6 years. And so here I am. So it says, this is my teacher, is right. What did I like to tell you? First and foremost, congratulations for first establishing a school of law and for the students for being the first cohort. That's always a plus in many ways. And so we are happy that you will be referred to as the inaugural students of this school. But that puts a heavy responsibility on you, and there are two things I would like to say, which are, sides of a coin. The first one is, please be committed to reading. Read. 65% of my life is reading. Just reading. And you read at two levels. You read to understand the world around you, what in terms of nature and society. And that's very important for you to be able to know your place in nature and your place in society. And then you will discover that you are a minuscule, a very, very small part, almost imperceptible part of reality. There are billions and billions of galaxies in this world. Billions of galaxies. And those billions of galaxies also contain billions of stars. So you can imagine that you are just in one of those galaxies called the Milky Way. And you are one of the planets that is going around just one of those billions of planets called the Sun. Luckily enough for you, the Earth is one of 8 planets. So you can say, well, I occupy an 8 for the stellar materials. So read. Apart from being invited, please read at the level of the units that you read. 2 people have said here, there is no option. You have to read the things that you learn in class. What you get in class is a very small percentage of the knowledge that is required of you as a lawyer. So read the things that you are supposed to read in class. The other side of it, unfortunately, because of the way these things are being used, we have these new things called LLMs, large language models, and that now is one of the most things. If you have read, you have noticed how many things go wrong with over-reliance on large language models. The first thing that goes wrong is that the current level of all these LLMs is that they hallucinate, meaning that they give out facts that don't exist. They actually manufacture facts. The second one is that they engage in something called slop, meaning producing information that is either unintelligible or is disconnected. Now, both of those mean that you have to check anytime you are using any of those LLMs, you have to against what you have received from it. But the second part of this is the fact that a lot of these LLMs actually tend to develop emotional relationships with the human beings. And the human beings then tend to forget that they are dealing with algorithms, machines that have been established, that have been fed information, and essentially part of that information is to make you their friend. And on account of that, many people have died or become mentally ill because they get too connected emotionally to these machines. So if you are using them, please use them knowing that one, you have to check the facts that you get, and two, they can entice you into mental instability, including suicide. But they have a positive element, which is what I would like you to embrace. Please be committed to your education and be committed to the society in which you live so that your education can be used to improve the lives of the people amongst whom you live. That starts with your community here, goes into the county, goes into Kenya, goes into East Africa, goes into Africa, goes into the world as a whole. Can you make the world a better place when you get out of here? Thank you.
Thank you very much. You know something about teachers. You think you have ideas. Okay. I'll say this before it sits down. When I got to the law school, and I was this firebrand who believed in God. So powerful. I still believe in God. But the way and then it gets into the first class, you took us through metaphysics, billions and billions of dollars, and how I am a very small person. And the next thing is, you went into a very serious investigation about existence and whether it makes sense or not. And at the end of it, we became friends. And he's one person who, even when he was dean, he was approachable, and not just that, he was ready to have people learn from him. So I know that you may never get an opportunity enough to say this, but Mwalimu, thank you for helping us be who we are. Asante. Thank you, Manager. Asante. And we are talking to the Dean and Mwalimu. Maybe you could walk the corridors of this place. I know you still look very young and you can do much more. I am tempted, and then I ask you to
but now that they're here, they should be walking and then eventually they run. And they can run and run and run and leave us with other faculties doing our things the way we normally do it. But having said that, before I call the other guests, you know, I want to invite a person here who has made this program acceptable. You know, if you people didn't know the students and the staff, from where I sit, every day somebody is lighting fire. From where I sit. Every day I come and I find fire burning. And all the fires, one of the main fires, chief guest, which burned for a long time, was how can you start this program? Who has given you the story? And even if you think you have a father who's given you, hey, stop it. These are our people. And you know, if they keep on saying they're using this one learned. You know, I was wondering when I was sitting there, where they belong. And I'm told that the learned is only not that they are also learned, but this was a profession for the Lord. The Lord. If you are not coming from the Lord family, you do not do Lord. So you can imagine how many people here would have done Lord. Because I know most of us are not from the house of Lord in this country. Or even if you do the pecking order, the Lords are very few in this country in our sense of the Lord. So now that we are joining that club, sometimes I would also do one thing, that now that we are doing law, don't be surprised that Dr. Koa, who is not a learned friend, will say, my learned friend, when they are in their bundu somewhere, that you know, just like non-teaching staff, which we normally know, you go into town and they don't see you there in some corner, and they're called professor. How are you? Then they yeah, and so we want now to be also learned, and it is you people who will make us learned. And I assure you that from where I start, we are going to do everything possible to make sure that this program, named after a nominal person, becomes the best in this country. That one I will commit in terms of support, in terms of resources, and in terms of making sure that we work. that because I can look back to see where we started with this institution and where we are. And so, before I leave this institution, because eventually I have to, that one is something I know every day, and I count my days and hours and seconds. But before I leave, I want to make this institution one of the best public schools and programs. And you see, my colleagues have owned up to that they want to be part of the best. So that we give that feeling of the university you have always dreamt about. When you are going to the university, you want to see a university. And Madam Chief Registrar, these young people daily, my office is placed in such a way that they don't. Sometimes I spend even 30 minutes just looking at the window. The number of photos being taken in this university, am I lying? Is unbelievable. When they leave class, you see some of them being like this. And then those photos go far and wide. Reason is because they love their environment. And therefore they love their school. And they want it to be so. So we are having a lot of responsibility that we must make sure it happens. And among us are also people who are in private universities. And when they come, actually, government people and most people come and say, is this a private university? Then you tell, no, we're just public. How? And Chief Registrar told you the first thing that I did, and I insisted, and my colleague said, here, students go to the washroom sitting on them. And if you take it to the student washroom, the people who have engaged to work there must clean it. You either clean because that's the job you came asking for, or you leave. And these students will tell you, I've never gone to any toilet where they are climbing. They sit because it's clean. Am I lying? And I've insisted that that is how we want to live. These people should come out there and appreciate themselves. So we started this faculty with a purpose. And the purpose you saw today. Congratulations to you all. These students are 1.5 months old. But when they were talking, I thought they were not students, we imported students from some university. I was not believing that there are students of 1 month old who would have the confidence and the language. Some of you surprised me. There are people who will say, this nowadays, these people are just like chat, GPT, all these particular things. But when they were talking, I was shocked. What then if you are 3 years old and 4 years old? I want to take this opportunity, not to take much time, and invite the lady who held the key. She is representing the Council for Legal Education. But her duty there is also to accredit. She is not just representing. She was the one who would say, no, you've not done it and you don't get it. Then it can give the board their report, and then the board decides, then finally we are accredited. So that daddy came, worked with us, with all the challenges. I tell you, I still call them challenges because we have not done our best. And our best is coming today. And I said, after they have accredited us and have a faculty of law, I want this faculty to be the best. And you can see we have given it the best in the form of a name, first and foremost. I don't want to put that light under the table. I want that light to be top here so that people can see the faculty. So, Dr. Onishe, you're welcome to come and represent them.
Thank you so much, Prof. He keeps referring to me as doctor. I'm not yet there, but I'm on the way. So thank you for the blessings in advance. Yes. So all protocols observed, allow me to just adopt that statement. Good afternoon. but also to acknowledge the great people in our midst, the former registrar of the CRJ, Chief Registrar of the Judiciary. It's a pleasure to sit in your midst. Mwalimu Wangoya, legendary. Okay, Chowiti, hey, I'm humbled. Especially the way he looks, he's taking care of himself. It's a challenge. And all the teachers, because I consider myself a teacher. I'm honored to stand before you this afternoon on this great occasion of the launch of the CMG, Agwingskotek Faculty of Law, Tomboya University, which was established this year. I stand here wearing the hat of the Council of Legal Education, where I work as a director in charge of standards, licensing, supervision, and compliance. So that gives you what we do. We set standards, we license, like we have licensed this institution, then we supervise, and then we ensure compliance. So accept apologies from the CEO, Professor Mwimali. He was invited, but he couldn't make it, and as well as the Director of Examinations, Dr. Felix Odiambo, and the Chair of the Council, Professor Colin Sodote. They couldn't make it, reason being we are starting the bar exams next week. So they sent me to represent. We are quite busy on the ground, so I had to come and represent. So allow me first to congratulate Professor Tomboya University for this great occasion. It's not a small feat, it's no mean feat. We have worked with them. I joined the council in May, and when I joined the council, one of the biggest problems that was on my plate was Tomboya University. We were informed these people, they applied this time, and vacancy this long, and starting to boil. And we had to act very fast. And I'm proud today to be associated. I'm very happy for you. And what I was joking with him this morning is that it's the only faculty of law that carries the names of two heroes. CMG, Agwingskotek, and Tomboya. So it's going to be a very great law school. To carry, it has weight, isn't it? Two names of heroes. So congratulations, very proudly associated. On the part of council, to the management, the message is, let's keep the standards that we have set. I don't know who I was mentioning it to, that this is actually a model public law school. A model public law. You cannot find a public law school in Kenya with this kind of standards. And when we came here, I was very impressed. So Prof, let's keep up those standards. We have a few things to do, but I think where we are good. So we can confidently say that you've started well, and we hope that those standards are maintained, and you meet the conditions that have been set by council, and we continue to work together as the Council of Legal Education. We will keep coming. We normally do, I think, an audit. After 2 years, we'll come and see how you're doing. Then after 5 years, then we will ask you to apply for a renewal. But so far, so good. We are very proud of that. To the teaching staff, I've met Professor Amwara. We taught together at Moi University. Dr. George and Fiona. Fiona was my student. Have I acknowledged my students? No, I have not. Let me first take a break and acknowledge my students. Pinter was my student. Fiona was my student, your lecturer. And Okore was my student. So you see, I'm a grandmother, a teacher, a grandmother teacher. So yes, so to the faculty, you're teaching the first cohort of a faculty. And essentially, you're setting the pace. So I'll urge you to keep the standards high. Start high. You can only start high, so that anything else has to go higher than that. But I know Professor Wamora is up to the task, so I have no doubt in that area that he will do very well. The only thing I'll ask the professor is that please get them more lecturers, because they need more as the faculty grows. And so mentor the next generation of lawyers. You know, being a teacher, you always have this passion to see people excel. It makes you very happy and proud. So take that mentorship mantle very well. And it's a calling. It's a calling. When you see your products 4 years from now, I'm sure you'll be very proud that that you are involved as a founding faculty. To the students, I'm going to wear my teacher hat now, not the regulator hat. I changed my hat, now I'm a teacher. When I was writing these notes, I was just showing Fiona some of the things that have been said is what I actually wrote here. But let me just advise you. I'm a product of Moore University, class of 2002. The first class of Moore University graduated in 1999. So we were the fourth class. When we joined Moore University, the first class was in fourth year. And when we went there, we found that they had set standards and a culture, and they passed it down to us, so that we were very proud. We were an underdog then. You know, when Moore University opened, it was only University of Nairobi that was the university that was the only university. So we became now sort of an underdog. But we did not wear that badge. No, we refused. I remember we did moot court with Mwalimu Elisha Ongoya, and we beat them blue-black. Not despite the fact that we were a new entrant. What I'm trying to say is, the first lot sets the pace. You are the firstborns. I'm a firstborn as well. You live by, you have no option. It's the way of nature. When you are a firstborn, you set example. You lead the way. You show by doing. So that is the responsibility that is bestowed on you by God as the first cohort. God knows why you're here today. He knows why He put you here. So take that responsibility seriously. Work to make sure that those who come after you are proud of the name Tom Mboya University Faculty of Law. Make sure it is up to you to set that pace. Mentor those who come after. You may feel inadequate, you know. I know there's something about not having other people to look up to. Now you look up to some. You have to find that inspiration somewhere. Then now you set the pace for those who are coming. This has been said. I wrote it down myself. Read. You have no option. Okay? And not just law. Read everything else. Don't confine yourself to the law section. I've been there. The law section of the library. Go and read sociology. Go and read geography. Professor will teach you geography. He's a very good professor of geography. Read geography. Read about the world. Read literature. Read medicine. The world is becoming very multidisciplinary right now. You will go to court and you will be arguing a matter that is not purely law. So you need to open your mind. It's becoming a global market. You need to know almost everything. And that way you grow. So develop that culture of reading, develop the appetite to learn, develop that curiosity to know. So that you can only cure by reading. And when you feel you have read until you feel now I know, that is the time you don't know. Read. Okay? Finally, I think I've mentioned this, be mentors to those that come after you. As you set the pace, show them the way. Pass the energy, the vibe. Let me call it vibe because Gen Alpha call it vibe. I have Gen Alphas. Pass the vibe down. Pass the vibe down. Don't let it die with you. And when you're done, come back and help your school. Okay? So, Prof, I think I've exhausted my notes here. Let me say again, congratulations on the launch of the school. The faculty, you keep correcting me for the launch of the faculty. Congratulations from myself and from the Council of Legal Education, and we wish you very well as school grows. Thank you so much.
Now, I'm moving down the ladder. After the Council for Legal Education, we are now going to, amongst us, before I go to where the actual occasion belongs. In our midst, we invited a lot of guests. And nature has ways of doing most of the things. We actually, it's important to note that we invited most of the legal minds in this time. Some of them are my teachers, colleagues, and associates. But more importantly, the leadership of this county. It was important that we actually invite them to know every step of the way what we are doing to make sure that we help the local community, the nation, and the globe. So we invited also nearly, actually all our MPs. And surprise, surprise, majority of them are lawyers. Apart from being lawyers, I want to tell you, a majority of them who are ladies, honorables, are doctors. It's only men who don't have any time. And it's being said in public that it's upon them. All men in Normandy County, and Madam Peter will tell you administration, but ladies doctors, special doctors, until the governor is also back to school, eventually become a doctor. Because it's ridiculous to be in a society where the ladies are leading, the men are following. You know, there's this kind of idea that men think that they should be leading the ladies. But here, ladies are leading. And that's the reason why the chief guest is also a lady. It's not that there were no. We just looked around and then we realized, no. The best of it's mine. And when we were in the meeting, I want to tell the students and colleagues, I was telling them, this lady you see here, if people watch, this is a lady who gave the current president the oath. If you saw the person who was telling, read this. Some people did not even read their oaths properly, isn't it? But others read properly. And it was the lady who was, some men would have trembled. But, you know, when I see the chief guest, and you know we were also more or less, we are cohorts in the university. When I was in the university, and she's made great strides. But we also were very privileged for the MP for Karachuan to honor our invite. All MPs actually are in Beta. We have lost the wife of the former Senator, Dino Kajwang. She's being buried today. So all of them are actually, by political nature and party affiliation, they must go and bury their member. And also the party leader acting is also there. So they have to go and support the family. Bury Dino Kajwang's wife, who was a very prolific person in the ODM party. So that's why you don't see them there. But the Karachuan MP, is also a renowned economist, somebody's done a lot, decided to send not only Professor Wamwara's teacher, when he was young in primary, when he was still crawling and growing, taught him very well, carried his hand. So, and is currently the NAT top in Homa Bay County. So he was sent here by the MP for Karachuan, not only to represent him, but also to present his donation, which I also know he has donated several books, Constitution of Kenya, to our library for the students to go there, and so they will say we have two, so that you have more to read. So he gladly accepted doing that, and many more other people have also written to us saying that they will honor our invite with some kind of support. And that is, so I want to give him the opportunity also to do the honorable thing so that we can move to the next level. Thank you, Prof. Ladies and gentlemen, I'm Patrick Were Onyango. I'm not a product of School of Law, but I'm a producer of the School of Law at Tom Hall University, having brought up a one Joseph Odongo Wamwara. I know his background. He comes from a very humble background, and I'm sure the first time he wore shoes was when he was joining Form 1. This young man was so bright, and in fact I'm proud that I taught him the subject that led him to be a lawyer. So much as I have myself not become a lawyer, but being a producer of a flamboyant lawyer like Wamwara, then so I am. Ladies and gentlemen, I'm currently the Secretary of Kenya National Union of Teachers in Homa Bay County, and therefore, much as I'm not a lawyer by training, I am a lawyer by practice, because I defend the teachers, only that I don't quote parts of the Constitution. I did not come here as Patrick Were, but I came to represent a very resilient person, the shortest member of the National Assembly in Africa, south of Sahara, north of Limpopo, west of the Indian Ocean, and east of the Congo Basin. None other than Andrew Adepo Okuni. Adepo is a resilient person, very outstandingly, he is a patient person. Adepo made his debut in 1980 and continued to lose, not to postpone victory, because as Luos, we never lose elections. And he first made it to the House, and he is doing his second term. We continue praying for that young man who celebrated his 40th birthday recently. Ladies and gentlemen, I must say, now it is not me talking, it is Honorable Adepo Okuni now. And I'm privileged that I'm speaking on behalf of the member of the National Assembly, who himself is an economist by training, not a lawyer, but his main work today is making laws. He told me to congratulate my brother, Professor Ochola, and the entire team at Tom Hall University. Joseph Thomas Mboya, this university is named after, was a flamboyant person, I'm sure not a lawyer by training, a trade unionist, and remember, labor movement and law go hand in hand. Tom Mboya, they served a big space of recognition in the country Kenya or in Africa, but later, Tom Mboya University got him a space to be recognized in a very high level of education cadre. MP Adepo said he is so proud that Tom Mboya, the author of the temporary constitution that gave Kenya a prime minister with a queen as the head of state, this university is named after him. And therefore, this faculty of law will gain a lot from the pioneering giant in the person of Joseph Thomas Mboya. Tom Mboya was the Minister for Constitutional Affairs at independence. And in fact, when Kenya became a republic, after he authored the Republican Constitution, the roles of the Ministry of Constitutional Affairs
were retired to the office of the Attorney General as Mboya took on economic planning. And therefore, he authored the Republican Constitution which ran this country through to 2010, when we had the new Constitution also authored, or also fine-tuned by the doctrines and thoughts of the late Prime Minister Raila Odinga. Ladies and gentlemen, the name Tom Mboya therefore carries a big debt for you, the law students. That while here, you must also look at the contribution and legacy of this man who started young and died young at a mere age of 39. And finally, the School of Law has been named CMG Arguments Codex. I understand he became the first human being in East Africa to graduate in law. Can you clap for that? And the law students, your School of Law takes after the first human being in East Africa to be a lawyer of that high repute. Adipo Kwame told me, because of the passion he has for education and for the citizenry of Karachuonyo. Prof, if there is a student from Karachuonyo constituency, then we can have I don't know. We can have a behind the tent talk because MP Adepo wants to promote the people within his jurisdiction. So if you come from Karachuonyo, you can see me behind the tent, and I take your message to Honorable Adepo Okwame. And finally, he told me to bring, I think it is delivered, the greatest and best. Remember, for Christianity, their reference material is the Bible. For Muslims, it is the Quran. For governance and that is law, the reference material is the Constitution, and that is what Honorable Adepo brought in bulk. May God bless you, and we wish you well as you seek to become better lawyers in the future. Thank you so much. Thank you so much.
These are all copies of the Kenyan Constitution from the government papers. Thank you, sir. I now move to the next level. Before I move to the family, we are going to give them opportunity. I want to give my who is also going back to his institution to tell them there is danger looming. There is danger looming, and he is currently the man behind the law school in Kabarak University. And he told me that we've started, Madam Commissioner, Kabarak told me that they started with the interim license, which were denied because of consequences of being given interim, then you don't work. And then if you find it difficult to go and withdraw the certificate because the students are there. So people are abusing interim. Now there's no interim. So they started all over and all this, and I want to tell you that you don't know that one of your graduates, and I think he's graduated with a PhD in Kabbalah, was a council member in Komboya. Judge. And Judge are the people who are behind this university. Because I tell you, I believe in obeying authority. The council, being the owner of the institution, I make sure that though I have my ideas, but I must cajole them and allow them also to own. And when you do that, you work very well with authority. Because if you don't do that and there is no authority, then even if you have ideas, Yagi and his team have made sure that this university reaches. I have a vision, but that vision must be. So I want to invite Professor Ngoya also to make a remark. Then after that, I will now hand over this to where it matters most for us. And you've seen this face. Yes. Now you are seeing this face.
Thank you so much, Prof. Thank you so much, family of the late CNG Agnes Kotek. Thank you so much, Chief Guest. Thank you so much, CLE. I will defend you for the Kabarak's interim accreditation in a short while. And most importantly for me, thank you, the advocates from Homa Bay for making it, because you are the ones who are going to cushion this institution. And thank you so much, faculty, led by my very good student, Dr. Mwara. And thank you so much, students, for choosing Tom Mboya University for your studies. There are a few remarks to make, and I'll anchor them in historical context. When I got this invitation to come here, I got a feeling that I was standing in the middle of what I call historic reconciliation. History was reconciling itself. Why? Because I was standing between two names. Tom Joseph Odhiambo Mboya and CNG Clement Michael George Agungs Kodek. I struggle to understand the difference between Clement Michael George and the other one. But somebody guided me that it meant the luminary of game, the great son from game. If that person misled me, I apologize on his behalf. You see, for students, the politics of this country of the 1950s and 60s are very interesting to study. And I encourage you to study it. Tom Mboya and Agungs Kodek were great sons of this region. Whether you wanted to call the region Kavirondo, or whether you wanted to call it Nyanza, depending on the historical epoch, both Tom Mboya and Agungs Kodek were great sons. They sang in the same choir, but they sang different tunes in that choir. If one sang soprano, one sang a bass. One may have sung alto, one may have sung tenor. They sang the same key of freedom, but sometimes one read competing harmonies in that music when you listen to it. Both were undeniably brilliant, eloquent, and deeply patriotic. Now, here is where I found it interesting. One day, Tom Mboya wrote an article entitled "The Kenya Question, an African Answer." That article was sent to the UK for review and publication. A reviewer looking at that article denied that this cannot be Tom Mboya's works. He said this must have been written by Agungs Kodek. Meaning the reviewer thought that Agungs Kodek was more brilliant than Tom Mboya. Therefore, it follows that the intellect of these two, their brilliance, their eloquence, and the sense of patriotism were remarkably similar. Because from my own reading of the history of Tom Mboya and Agungs Kodek, certainly Agungs Kodek didn't write that article for Tom Mboya. Tom Mboya wrote it himself. But that reviewer believed that this brilliance can only be Agungs Kodek's, must mean that Tom Mboya was equally brilliant. Yet, Mboya was the polished statesman in the area of negotiation and order. Kodek was the fire-binding diplomats, friends of Tom Mboya, frontier to be fought for. And so, to this new law school I say, may your first tradition be inherited in justice. A law school that does not just disturb the status quo is merely a library with ambition. A law school that questions power is one that shapes history. You are here to shape history. As the first jurisprudence. Now, I know your first years. Law. Before the courts called him learned friend, even by that act of marriage was a lawbreaker. Why? Story, in defiance of racial segregation, the law for with a white woman. Colonial Kenya did not have room for Agnes Kodek's love. It was there for him to see. Kodek refused to choose geography of love was an act of law. He taught us that law's first client is human dignity, that law is not an abstraction of power, but an affirmation of the people. Justice was branded treason. One man dared to walk into the lion's den. I'm the only to the lion's den. I'm the only with his conscience and his gout. Somehow the colonial government, only with his conscience and his gout. Somehow the colonial government knows that your major voting constituency would be dissidents. So one of in impossible cases. Preserved life was not a nickname. Preserved life was not a nickname. It was a national honor. He turned the courtroom into a battlefield for freedom. Let it teach moral law. Let your graduates not only interpret law. We also expect justice beyond the courtroom. We expect justice beyond the courtroom. We expect speaking of truth to power. We expect this school. So therefore, as we open Agnes Kotek Faculty of Law, let it also do that.
That's the best December that I can. Now, the family. Make their remarks. All of them. For this gathering, before our chief guest comes and launch.
I will welcome the family with this manner. We've talked about water and all that, isn't it? So you'll collect manyunyu. Kabla ya mvua ni manyunyu. So you do this. Kisema radi. One hand the other, isn't it? And there's a collision. Manyunyu, radi. All right. Radi. Asante sana.
Every member of this family is going to say something, yeah? So what I'd like to do first is introduce to you and where we stand in the lineage. I'm the firstborn, of which I'm very proud. Also, son is this one, Gem Arkwins for that. The first grandchild is my daughter Caroline, and please do not confuse our names. It's Carol and Caroline. That is Caroline. The first lawyer in the line under Gem. Yes. Yes. Yeah, okay. I have to admit, let me just admit this to you guys. I come from hospital. It's been a bit difficult for me, but there's one I had to come and hear for you today. Give me a moment. Thank you. And Gem's son Patrick is the second. That's how it stands, and I think we need to invite, maybe, Dipley, would you like to say a word? I hope so. Please? Let's stand, Charles.
Good afternoon, all. I think the first thing that I would like to say is thank you. For end with thank you. I would really like to begin with thank you. To say that this Faculty of Law has been named after my grandfather, their father. With which you have done it, to all of you. So to yourself, Professor Chola, to Professor Wamwara, your whole docket. Dr. Avyambo, thank sasa ni yangu. So I think the first thing is to the point that was made earlier. But like was said, being a firstborn is quite hard. And being a firstborn is a privilege. Now you are all going to be firstborns of this faculty. Because you will have to be brave in doing it. Because you will set the tone. Okay, you will set the tone. I'm Armstrong, so my surname is different. My whole life, people have not believed that I'm an Agnes Quebec. Okay, it is where your first level of confidence will come from. It is that feeling that you belong, our sense of ancestry, which we carry everywhere we go. Now sometimes that can feel like a blessing. How you choose to look at them is what they will become. It's hard, even when you have felt like you're walking alone, and hopefully this resonates with all of us. It doesn't know what matters. Everywhere I go, CMG Agnes Quebec goes with me. The ancestors coming true. Okay? Okay? You will then go out into the world, and then the world will want you to earn. Jack said, law, life. Know that you belong, forge your own path as the firstborn, and there's no such thing, okay. That fight for defiance and for justice, she has embodied it.
For me to just Mulikas, your dean was my classmate. Humbling and meaningful to stand before all of you today, not just as an advocate, but as a granddaughter of a man whose name now graces this pioneer who used law not only as a shield, but a sword of justice. He passed away before I was born. It became apparent that his courtroom was more to speak about him, but I'm here as an advocate. Courtroom was more to speak about him, but I'm here as an advocate. As you begin your journey at this faculty that now bears his name, figure out what faculty that now bears his name. Figure out what is my niche, what do I want to do? What is my niche, what do I want to do? How do I want to then make the law work for me? It is such start your journey, want to then make the law work for me. It is such start your journey, start thinking about that now. Start thinking about that now. Think past the want to do litigation. Please, advocate, think past the want to do litigation. Please, advocates, don't jump on me. But I didn't want to do litigation. It was not for me. Can be jump on me. But I didn't want to do litigation. It was not for me. Can be very daunting. It's very daunting. It can really just play tricks on you. It can really just play tricks on you. It can be very easy as well to seek relief from. True fulfillment in the Lord doesn't come from excess. Too much money, too much drink, too much money, too much drink, too much partying. It doesn't come from that. It comes from the title or partying. It doesn't come from that. It comes from the title or the paycheck. Let your legacy be great. Legacy, as my sister has said, is that your legacy be great. Legacy, as my sister has said, isn't necessarily about replicating. So we set it like this, isn't it? We keep moving. We keep moving. So we set it like this, isn't it? We keep moving. We keep moving and we keep the bar high. But remember, if something doesn't make sense, go back and read it again. If something doesn't make sense, go back and read it again. All right? My phone keeps locking. Technology. Let's move to this way. Don't be afraid to stand out. Technology. Let's move to this way. Don't be afraid to stand out. and say, wait, this something about this isn't right, because most likely, say, wait, this something about this isn't right, because most likely, the people, thank you. Sovereignty, the people, thank you. Sovereignty belongs to the people, belongs to the people. So keep your constitution like a Bible. Are the judges, those people are. So keep your constitution like a Bible. Are the judges, those people are, the police. At the cornerstone of the law is the people. Police. At the cornerstone of the law is the people. So keep your constitution. In fact, I want you to always be able to just pull it out and be like, wait, this doesn't make sense, because you really said everything I wanted to say. But remember, when you keep the truth at the center, you'll never lose. But standing alone, but remember, when you keep the truth at the center, you'll never lose. But standing alone, got this gentleman, a faculty of law named a School of Law, may not only just be carved in the wall, but a living reminder. One of you have integrity, purpose, and courage. Never forget that. May this school, you are brave. Those who understand justice, not just as an idea, somewhere who could do, something that you come to the first year law students to the beginning of your own legacy. Thank you. States. Allow me to introduce my uncle. I'm sorry, protocol dictates the last one, the oldest speaks last. My uncle,
Many different points. I don't know what my sister is going to say. She might go in that heard. There's some things which I have not heard, and I don't know whether they're useful to you. First of all, I've not heard your voices, so I don't even know if you're here. Are you here? Seeing you guys in moot court, and I'm saying, gosh, these guys are so young. Some of the things I want to say at a personal level about my father, me, and us. Yeah? That's point one. Number two, 102 years ago, my father was, okay, people had finished building the pyramids in Egypt. We came down the Nile. Ramogi, there's a list of names of our elders, which I won't bore you with, because I don't know how many of you are Lu. My grandfather was the first generation of Christians. Dad was a troublemaker. He has gone how far back it was. He has gone how far back it was. He was expelled from, okay, so far. The Muslims in England did, because he had been to school with them. Is still with us up to today. And I think it will be there for history, which is really not over. I think when I see the names of Agnes Kodek and Tomboya together, I'll admit when Tomboya's name. It's okay, it's okay. I think history of Kenya can best be learned when you look at those three names together. Mboya, Agnes Kodek. Right? America. One guy was in the East, in line for him. You know, it was B1 Moy as the West.
This up. Maybe I need technical help from this up. Maybe I need technical help from the younger ones. From the younger ones. Rid of this oppressive colonial authorities, their policies in of courts, which you could liken to. Yes, because that's where he was called to be a barrister, so that he could. Yes, because that's where he was called to be a barrister, so that he could practice impers. And practice impers. And he was taken on as a senior legal aid, was like speaking legal aid. And that's the only thing they could do, because they were denied any kind of living arrangements in any everywhere with it. Anyway, moving to this after we kept talking about my trans news. Oh, something else? Okay, and you came up with a Hiroshima Nagasaki Congress Party. Parliament in UK. And it was discussed, Parliament in UK. And it was discussed for a matter of almost initiative. So that went on, started another party a whole year. So that went on, started another party a whole year later. That went on, started another party a whole year later. So we're later. So we're in district, but you have chosen it, and district, but you have chosen it, and I ask all of Central and Southern Africa, right? Here, an unwavering commitment to justice. All of you, I know it's not going to be easy, but you will feel at the end of the day. And when you go, and you become established lawyers. You know, I was there when they were first starting up. How I'm allowed to address you all here today. Deeply honored that you chose my father to be the representative. Much for listening to me. I appreciate it.
Yeah, to the family. Now, we are coming to the climate issues. The family and all that to carry the torch of this great man and university that was going to make sure that this focus does the right thing. Now, let me take this time so that she can launch for us the CMD Agri Conference faculty. And CBS, Chief Registrar Americas, the Judicial. I'm being told to give one introduction that she also comes from what a coincidence.
Sorry. Okay. Let's give the chief guest a standing ovation by just standing, and she's here with us, and we give her the opportunity to address us. Thank you.
Thank you very much. Good afternoon, everyone. I know we're all tired. We've been here for a while, but those have been very interesting conversations. And I'm sure we've all learned something. I thought I knew about CMG against Kodek, but I've learned so much more about him this morning. And as I was seated there, I was just reflecting on the coincidences that I see today. Because sometime back in 2016, we went to break ground for the new CIA High Court building, and this family was there, together with Emeritus Chief Justice Willie Mutunga. A few years later, when it was completed, we went to launch the court. And I had a list of all the great minds, legal minds of Sierra County. Obviously, the first one was CMG against Kodek. And made a request that the court be named after one of the great sons of Sierra. There was Okombaka, there was James Orengo, there was so many others. And guess what Sierra Law Court is called today? Any guess? Sierra Law Court? CMG against Kodek again. And today we're here doing the same thing. So I don't know what that means. For those of us who believe that life is spiritual, it must mean something. I don't know what it is for now. But Vice Chancellor, first of all, may I just begin by congratulating you on this achievement. The entire faculty, the staff, distinguished guests, ladies and gentlemen, good afternoon once again. I'm so happy and proud to be here this afternoon, just standing before this august gathering to mark and preside over a truly historic and momentous occasion, which is the launch of the law faculty bestowed the name of CMG against Kodek, the first Kenyan, Black Kenyan barrister. I feel privileged, I feel honored, I do not take it for granted. Congratulations once again. I take this early opportunity with a lot of humility to thank the CMG Agnes family for granting Tom Mboya University and the Faculty of Law in particular the utmost and profound privilege to assume and use the identity of their beloved and revered patriarch, entire son of Kenya and Africa, CMG Agnes Quebec. From the attributes associated with this gentleman, and everyone who has spoken before me has said so much about him, we've learned so much. For me, this is a most defining step that this university and the faculty have taken in their decided journey towards attaining the remarkable tradition, attributes and association of excellence, both now and for the future. I also wish to extend my heartfelt thanks to everyone who made the dream of the Faculty of Law in this university a reality. Tom Mboya University Council, the Vice Chancellor, the University Management Board, the Senate, staff, students, Commission for University Education, Council of Legal Education, the dedicated founding faculty, and those who might have provided whatever resources in one way or another. Thank you so much. A new Faculty of Law is more than just a new building, and it's a beautiful building, Vice Chancellor. We were just discussing with Ngoya, who also thought Agnes Quebec was an Indian, and saying that not many of our public institutions look anything close to this. Well done. So it's not just a new building, it is a commitment to an ideal, the pursuit and advancement of justice and the rule of law, and a center of preeminence in providing quality legal education, training, research, and consultancy. I've also noted that this faculty is committed to incorporating the aspirations of the Kenyan people and the global community by generating, preserving, integrating, transmitting, and engrossing legal knowledge with special emphasis on water resources and blue economy. I'm confident that this will not just remain ideas in the founding documents, but they will also be actualized in every faculty, staff, students' experiences and contributions to this faculty. I would like to challenge all stakeholders to internalize and actualize these aspirations starting now and in the future. And I think, I forget your name, Samantha emphasized that as well. Distinguished ladies and gentlemen, I'm particularly excited about this faculty's unique niche in the area of water, maritime resources, and the blue economy, and the commitment to leveraging ICT skills in legal practice. I believe that the graduates from this school will be well equipped to face current and future challenges in a changing world. I also note with a lot of excitement that the faculty has been very deliberate in teaching both Kenya Sign Language and French. Just based on my experience in the judiciary, the institution has struggled a lot with getting sign language officers, especially when dealing with litigants or witnesses who are hard of hearing. And we are also learning French. In our time, we did not have these privileges. My teacher of HOET is here, and it's great seeing you after a long time, getting younger instead of getting older. Don't you agree? So we did not have the privilege of learning anything outside of the law. So you are indeed in the period of grace, as Professor Ngoya would put it. The world has become a global village. In training for the global market is a creative and appropriate thing to do. An extra language, extra tools, extra techniques, always the first step to getting into the very, very competitive global market. It's almost 57 years since the death of CMG against Kovac, which occurred on the 29th of January 1969. We've heard from all the speakers that he was the first indigenous African Kenyan lawyer and the first, indeed the first East African to qualify as a barrister at the Inns of Court in London. And just over half a century since his death, since he was called to the bar, today thousands of Kenyans have gone to train and qualify as lawyers. By the time I was leaving the judiciary, I think we had about 20,000 in the role of advocates. They have also taken up various legal and multidisciplinary roles in the public and private sectors, in civil society, in the corporate world. It is indeed very inspiring that the Faculty of Law at Tomboya University has been named in honor of the late Atkins Kovac. As we have heard, he belonged to a crop of Kenyan pioneers who had a vision of greatness for this nation. A crop that believed that Kenya could be a soaring giant in the community of nations. This crop believed in the inalienable right to human dignity and individual progress expressed through the empowering reality of our cultural identities. And they've been fed to a lot of that information and history this morning. For them, ethnic identities were not a fault line to be avoided, but a beautiful mosaic of unique and necessary diversity. Just like his peers, whenever he found an opportunity to defend the rights of the oppressed, he never hesitated, even at the risk of danger to himself. And I hope that all the students sitting here will follow those ideas when the time comes for you to go out and practice. That is why he exemplified himself as a freedom fighter and my lawyer. It is also for this reason that whenever he got an opportunity to serve the young Kenyan nation, he served with unmatched excellence. And that is our wish for all the graduates of this institution in the future. Distinguished guests, ladies and gentlemen, it is for this excellence and conviction that I believe we have decided to name, this institution has decided to name the Faculty of Law at Tomboya in honor of this great son of Kenya. It is these ideas that we hope will be recreated in every student sitting here today, in every staff and faculty that will have the privilege of walking the corridors of this Faculty of Law. To the students, you are the first cohort in this institution, the law school. Congratulations on your admission. I had the privilege of sitting at your moot court this morning, and I couldn't believe you just have had about a month and a half of learning. I can tell you that as a first year, way back in 1985, if someone had asked me to do what you did today, I would be shaking and wondering what to do. Very impressed. I think we're on to great things, and we look forward to a bright future for all of you. You are the torchbearers of this new faculty, and you've been given plenty of advice by all the previous speakers. I hope you are listening. I don't know if you took notes, but if you follow everything that you're told this morning, you are going to succeed. The path ahead will require hard work. It will require discipline. You're not just here to get a law degree. You're here to be shaped into legal professionals who can effect positive change in our society. I urge you to interact with your diverse peers, make use of the support systems that are in place, and remember the words of Mahatma Gandhi when he said, a true lawyer is one who places truth and service in the first place, and not money. It's a good thing to make some money, aim at that as well, but do not forget that truth and service comes first. In the leadership, to the leadership of this faculty, led by Professor John Omaya, I know you as an ambitious and talented young leader. I know I worked with you when I was in the National Legal Aid Program, and we did some work with the Moi University Legal Aid Clinic. I'm looking forward to a day when this school will have its own legal aid clinic to support the community around, and I'll be happy to participate in that as well, because I have all the time. Professor Amaya, I'm just urging you to assume the challenge of setting up a school with grace and explore all the options for growth that we discussed in my meeting with you and the Vice Chancellor the other day. You have such a rare privilege to be part of the founding faculty. Bear this responsibility with pride, with courage. It comes with a lot of challenges. But sometimes you say work is not work unless it is something you'd rather not be doing. So the faculty will be relying on you to set the example for the rest of the team, the rest of the students to follow. To the leadership of Tom Mboya University, led by Professor Charles Ochola, I got a chance to discuss with you about the establishment and the naming of the faculty. I'm convinced that your vision forms a firm foundation for the excellence that we dream of for this faculty. Keep believing in and supporting the Faculty of Law, and your steady and informed leadership will go a long way in making the best, this school the best in the nation, in Africa, indeed globally. To the leadership of our hosts, unfortunately they are not here. We are told they are attending the burial of one of their colleagues, the wife of the colleagues. This institution offers a great opportunity because law, loosely defined, is a science of leadership. The leadership in this region has the opportunity for leadership training at this faculty, and we hope that we can reach out to them and endeavor to be quick to send and sponsor students to this faculty, and even to help in establishing bursaries and scholarships. I'm so happy with the representative of Honorable Adipo Kwame. Is he still here? I think he has left. Honorable Adipo Kwame, who is my member of parliament, undertaking to support by way of keeping some students here, which is a good thing, and I hope that the rest will follow suit. We hope that the leadership of not just Homa Bay County, but neighboring counties as well, will be reaching out to explore constant and meaningful partnership with the school. Distinguished ladies and gentlemen, the naming and launch of the CMG Agro-Scholar Faculty of Law today marks the start of a new chapter. I invite everyone here to participate in and support the mission of this great faculty. Together we will build an institution that we can all be proud of in this region, in this country and beyond. There is in place decision, which was communicated to us earlier this morning, and now it is time to do the work and turn our dreams into reality. I thank you all for being here this afternoon, and I to supporting the institution in whichever way that I can, to ensure that we all uphold the ideals of justice and excellence. And with these not so few remarks, I want to take this opportunity to declare the CMG Agnes Corbett Faculty of Law at Tomball University officially launched. Congratulations and thank you very much.
We're launching a law school in South Nyanza and we don't have any relations, surely. Yeah, we should be standing, yeah? So, I think we'll do this, yeah? When I say one, you say C. When I say two, you say M. When I say three, you say G. One. You guys have not gotten the instructions. When I say one, you say C. When I say two, you say M. When I say three, you say G. And when I say 1, 2, 3, you shout C and G. Okay? 1, 2, 3, 1, 2, 3. Thank you. Yes, for the cake cutting, there is our friend Anne who is assisting us. Anne, please come. The faces are finally brightened, Yes. The CMG family, please come to assist in cutting of cake. Professor Ngoya, in town, please come as well. Come so that Madam Kuniche, come and license the cake so that we all have it. Yes. Faculty, Dean, and the rest, you can also join so that you are captured together with Madam Koniche representing CLE. And let the record reflect LSK kindly honorable. LSK honorable. So that we capture this in a magnanimous manner. While they are cutting the official photographer, please ensure that you capture all these people, representatives from various sectors. We have advocates, we have the faculty, CMG family, ladies and gentlemen, guests, Professor up there, the founding faculty, We've said students are the founding students, but we've not said enough of the founding faculty. Yeah. The chief guest is testing wewe unakula kwa macho, isn't it? Yeah. Inakuja mstia wasiwasi, I say. Once our guests and visitors have tasted, it can be done in pieces and remember the MC. Oh, Gallo, relax, relax. Madam Konucho is saying it is an academic cake. Yeah. While we are proceeding, we also had senior lawyers like Cecil Orlando coming around, and you know, the house is full. Senior. I'll test and confirm on behalf of those who have not tested yet whether it is sweet or otherwise. All right, even after the cake cutting, we will be having a brief photo session. So you can leave immediately after the cake cutting and everybody has tasted cake, we will have a photo session in the following order. We'll have all the LSK members. The guests will be the ones that are not leaving. So the guests will sit in the seats that we have here, and then we'll start with the LSK members. We'll start with all the faculty of Tomboy University. And then we'll go to the School of Law faculty. And then we'll have the finalists of the mid-court competition take a photo with the guests. And then lastly, we'll have the students. So the guests will be a fixture, and then the rest will come as fittings. You come, you are beaten, and you go. Yes.
Yes, let's do the vote of thanks.
All right, just before we do the photos, I will have a vote of thanks moved so that immediately thereafter we take photos, and after that we will then congregate for a sumptuous lunch in honor of CMG. So we welcome the DVC, Professor Eli Joy Mishini. We will move the vote of thanks. I'll request that we assume our seats as the vote of thanks is moved, and then I'll request you to come back to the photo session. Professor Karibu. She is saying it will be very short, you can even stand, but just for purposes of order, we can resume our seats kindly.
Sorry?
Sorry, we will have a vote of thanks. For the guests who are here, like Professor, you can sit, because either way you will be here. So we will have the vote of thanks, and then we shall get into the photo session.
Good afternoon. Good afternoon. Those who are here can take this seat as we move on. Riding on the protocols that have already been established. All right. Okay, mine is very simple to give a photo of dance. I believe it has been, even as you continue taking the cake, it's all right, you can do the two together. Yeah, just leave the students, they keep serving themselves. Oh, the day has been great. Students, you have learned a lot, isn't it? Very good beginning from very experienced people. So, first and foremost, we thank the Almighty God for the gift of this day and for making the official launch of the Faculty of Law a reality. We have to acknowledge God for that. It has happened. Thank you so much. Sincere appreciation goes to our chief guest, Honorable Anne Amadi. We are deeply grateful for your presence and your inspiring words. Your support and insight will guide us as we build this faculty. Thank you so much, Madam. To the family of the late CMG Agnes Kodek, we extend our sincere gratitude for allowing us to use his name for our Faculty of Law. I must say personally, I've learned a lot about CMG, something that I didn't know, all the way from Professor Ogoya, the kind of comparisons that she was doing. I believe all of us have learned a lot. Thank you so much, family, for allowing us to use his name. Our sincere appreciation again goes to our Vice Chancellor, Professor Charles Ochola, for your visionary leadership and unwavering commitment to excellence. Ask me, I'll tell you before we got where we are with that program. He has been on his toes. Please let's appreciate him. We also thank the deans and heads of department for their collaboration and encouragement throughout this journey. Deans of faculties, those who are here, please raise up your hand to recognize you. We have walked this journey. Our heartfelt gratitude also goes to the Commission for University Education and the Council of Legal Education represented today by Madam Konuche for their invaluable guidance, support, and oversight in the establishment and accreditation of our Faculty of Law. Your contributions have ensured Madam, have ensured that we meet the highest standards of academic and professional excellence. That is why we are where we are today. Thank you so much. A special round of thanks to the Faculty of Law team for the good planning, dedication, and hard work that have brought this dream to life. Professor Wamola and your team, thank you so much. We also appreciate our partners, sponsors, and the guests from the legal profession. Your presence, your speeches today strengthens the bond between academia and the legal community. I think students, you are learning from the best. You agree with me. To our students, thank you for your enthusiasm and the faith in this new beginning. You are so keen. And that is why our guest of honor actually looked at you when you were in the moot court presenting and said, yes, when I was a first year, I don't think I would get to this. So students, you have done well. And please, I want you to know that you are the reason we strive for excellence. So we will also be on the lookout to ensure we release the best to the field of work. Finally, our gratitude goes to the organizers, the media team. If you are not aware, this event is live on social media. The support staff, you have seen some of them who have come here. Their efforts really made today's event a success. As we close, May God bless this new faculty of law and all who will learn, teach, and be served within it. Thank you very much.
A round of applause for Professor Mchini. Thank you so much. So this shall be the order of events. Slowly or shortly after this, we will have a closing prayer from senior member. Then thereafter we will get into the program will be converted into a photo session venue. The ones who are sitting will remain constant, while the rest will be joining and taking photos for purposes of record and posting. Yeah. So we'll have our guests together with the CMG family stay and sit right here. And then we will have the LSK members taking the first opportunity. Everyone who is assigned the role of advocates, you will come and we will have a photo, then we will leave it to the faculty. I've seen deans from other faculty, all the faculty members of Tom Mboya. You will come and take a photo. Then thereafter we'll have the founding faculty School of Law taking a photo together with the guests. After that, we'll have the finalists for the mid court. They will be honored because I remember when I was the first year, I attended the first moot and I was the last. Yeah, I was the last. Yeah. So the finalists will come and you will take a photo, and then lastly the students will come. Then thereafter there is lunch that is prepared for us. On the 7th floor of the building, we have 2 wings. So be very careful to note the tent that you'll be entering, yeah? So on the wing that faces the lake, it is left for the good guests. So if you enter there without having the tag of a guest, don't hold it against me if I do otherwise. So anyway, there is still the same food. It is just an issue of space. It is the same food in the other wing, the one that faces the mountain. It shall serve the students and the rest of us like me. All right. So please ensure that the 7th floor, at least that one you will not forget, the 7th floor, 2 wings, the wing facing the lake is for the guests. The one facing the mountain, let me call it, is the one facing Asego, Gotasego. Yes, I'm a local. The one facing Gotasego is for the rest of us. So if that explains how we will move. And lastly, after lunch, the students are reminded to stay around. You will be meeting our very own Professor Ongoya. You know, meeting Professor, I don't know what, do you know what you will be doing? So if you want to miss that, who want to? I'll tell you that advocates wait in court just to pose for a photo with the professor. And I said here earlier that and I stand to be corrected, yeah? At present, one of the best cross-examiners, yeah? And a teacher of, actually not one of the best. Without saying much, the best cross-examiner. And the best teacher for court conduct, yeah? If you want to do litigation, then when you are revising or when you are chilling, you just go to YouTube and look at those places where witnesses are being forced to say yes or yes, isn't it? Yeah, and you learn 1 or 2 things. So I think that explains the nature of how we proceed after this. So we'll have a word of prayer. We can rise.
We are praying.
Our dear Heavenly Father, we are standing unto you this hour. Like that one leper, we say thank you. We give you praise, we give you honor, we give you all the adorations. You are the reason why we are gathered in this place.
Lord, we have enjoyed your help. We have enjoyed your backing through this occasion. We are saying thank you. Even as your people are departing from this place, let your abounding mercy abide with them forever. Lord, we are also praying for the food that we are about to take. We bless it and sanctify it as the body and the blood of Jesus Christ. We give you all the praise and honor. For in Jesus' precious name, we have prayed and believed.
Amen. All right. We're clear. So we move with sorry. The CMG family, you'll join the guests.
Yes, so LSK members, please. The guests are already here. This is official photo session. Wale watu wa Oppo na sorry? No, you are sitting as the constant members. The rest will be coming and going. Yes, you are the permanent. Yes, the CMD family, you can join us, please. We have one seat. All right. Okay. No, you can, Samantha, you can sit while you can sit there to represent the family, and I will request the good gentleman Game to just stand right behind. Samantha, you can sit right there. Yes. All right. So LSK members, please. But before that, we can take that photo. Official photographer, have you taken record of this? Oppo and Techno, wait. We will not disturb the quality of the official photography.
Samsung and iPhone, you can compete. CMD family. Daktari, you can come please for the CMG family so that it goes on record that the faculty was present and serving with me here.
Now this is the time to unleash.
Whether real or passive.
All right, thank you. Law Society members, the ones sitting, continue sitting. But again, you can remain there. Yes, and the family. Law Society members, kindly, if you signed the roll, at least I signed it when CRJ was still in office. Yeah. So please, LSK members, let's balance. I know mathematics is not our strength, but you can check which side does not have more people and you stand there. Yes. I am also part of this. Kindly don't cross me.
Have we all been seen?
All right, thank you. LSK members, asante sana.
CMG family and the guests, you remain. The School of Law faculty. School of... The faculty, the whole faculty of Tom University.
Lecturers, members of various schools, or other faculties within the school, this is your time. You can come on already engaging your smile so that we take many more time. Yeah, you come when you are ready. We would like to thank you in a very special way for making time to be here to support the Faculty of Law, which is now your small brother. Faculty members, let's balance. I know Faculty of Mathematics is represented. We can balance over the two sides. Yes. This is appearing too big. Will it fit the megapixel? Or you want to make it a little bit? Please balance, yes. The ones who are vertically challenged, you can stand at the front, while the others who are like me. Yes. I'm not part of that. Please confirm that everybody is in. Now this is the time to engage the smile. Lecturers are very serious in this university. Yeah. Thank you for the academic smile. All right, this is the time for the finalists. Those who made it to the final. I was telling you, I got to my first meet and I was the first year. I hadn't prepared. I just went there and heard what people were saying, and then I registered as the last person, said what I had, became the last, but it was a turning point. Shortly thereafter, became one of the very serious mooters for Moi University. Finalists, both the respondent and the appellants. I was sitting in court and I was hearing Professor ask about the presumption of constitutionality to a first year. And I thought, next in line, of course, is the student.
Next in line is the students, so the finalists, is your time to shine. Yes. Yes, that was half minimum movement. Yes. What the reason is why he's sitting, I cannot see why he's standing anyway. Yes. All right. So this is the finalists. Please balance.
This is the time to say cheese. All right. So for minimum movement, the guests will sit at this, right here, and then the rest will remain seated. So for you and this wing, you want to join the majority on the other side, so that we arrange ourselves in a very perfect manner, and we receive a beating of that photo, the launch for today. So the faculty.
Say that I can never be all that I see. I've seen that God is greater than that. Who can battle with the Lord? Nobody. Who can change his mind around me? Through many years, in many ways, I have seen his faithfulness ever and ever.
Tribulation. I bring you good news where you cannot refuse. Hold on. I told you with Christ that you can never lose. Oh God. Woman, I beg you give me your attention. Very, very soon you will share your testimony. One by one you will tell your testimony. Bigger than money, we say sweeter than honey.
Congratulations, you're in the glory of God. Congratulations, he has done it for you. And you'll come back with a new song to sing. Your God is good. Oh.
One day
You will come again with a new song of praise. God is
go check while alongside the day. Two are we together in a celebration.
I have a message for you. God has sent me to you. I have a message. Congratulations. I have a message for you. God has sent me to you. I have a message for you. God has sent me to you. Listen, them say, them tell you say you can never be the one. But God say, make I tell you say now you him choose in 1 month, in 1 week. You will sing a new song in 2 days, lesser than you will hear. Congratulations.